This is a special Supreme Court argument recap brought to you by the American Bankruptcy Institute. I am Bill Rochelle, ABI's editor-at-large and columnist, and sitting with me is Professor Andrew Dawson from the University of Miami School of Law. The professor is ABI's scholar in residence for the spring term, and we sure are glad to have him here.
Thank you.
And the both of us are very pleased that today, the 17th of January, we were able to sit in the courtroom at the U.S. Supreme Court and watch oral argument in Midland Funding versus Johnson. This is a case under the Federal Fair Debt Collection Practices Act, or as we will call it, the FDCPA, and it raised two issues. Number one, did the Bankruptcy Code, which was, by the way, adopted after the FDCPA, did it impliedly repeal part of the bankruptcy, part of the FDCPA? And the second issue is, does the filing of a stale claim, and this is the biggie, does the filing of a claim barred by the statute of limitations amount to a violation of the FDCPA? And as a matter of fact, if it does, it automatically entitles the plaintiff to recovery of counsel fees and to $1,000 in damages, even if you can't otherwise prove damages. So tell me, Professor, what happened in the 11th Circuit from which this case came?
Well, the 11th Circuit found that filing a stale claim in bankruptcy is a violation of the FDCPA, just as it would be if the debt collectors had commenced a collection suit under a stale debt outside of bankruptcy. They also found that there was really no conflict between the Bankruptcy Code, and the FDCPA. They found they can work in harmony in the sense that although the Bankruptcy Code allows for the filing of claims and defines claims very broadly, it doesn't make you file claims. And in fact, the FDCPA is outside of the scope of bankruptcy in the sense that it's regulating debt collectors. It's not regulating the claims resolution process the way the bankruptcy law does. It's actually regulating a portion of the industry that deals with the debts of others.
And so, in other words, because the two statutes can live together harmoniously, there is no preemption of the Bankruptcy Code of the FDCPA.
Right.
Okay. Well, very good. So tell me, you sat there, Professor, and remembering we have only 8 justices on the court, how do you see the vote coming down?
It's hard to imagine the consumers here getting more than 4 justices on their side.
And who would they be?
It seemed so. The Justices Sotomayor, Ginsburg, and Kagan seemed to be most sympathetic to the consumer side.
And who would be the 4th vote if they might get it?
It struck me as Justice Kennedy was at least sympathetic to the argument that what the debt collectors are really doing is gaming the bankruptcy system by trying to slip one by the bankruptcy trustee.
Right. Interestingly, and I agree with your analysis, absolutely, Justice Breyer is the one justice who I really think is day in and day out the best versed on bankruptcy, but he seemed kind of hostile very often.
He was not sympathetic at all to this idea that filing a stale claim would violate the FDCPA.
Well, you know, when the argument started off, the first real comment came from Justice Sotomayor. And if I may quote her, she said, "I have a great deal of trouble with this business model." And by that, she meant that basically hedge funds buy up claims where there is no right to collect from the debtor. They buy them for fractions of a cent on a dollar, perhaps. And then they have computer systems that will allow them to file claims at very little cost. And what they rely on, so it is alleged, is that some of these claims will simply slip through the cracks, and trustees will not have the inclination or the financial wherewithal to object to claims. And so therefore, the debt collectors make money on claims which otherwise are worthless outside of bankruptcy. And Justice Sotomayor really jumped right on top of that. And I think Justice Ginsburg did too, if I recall, and also Justice Kagan just didn't see the business justification for this. But
On the other side of that, Justice Alito seemed to say, well, why don't the trustees come up with their own computer system that would automatically object to every stale claim?
well, that's a very good point. But of course, the bankruptcy rules, I don't think yet really allow for the development of a good computer system that would infallibly accomplish just exactly that. I must say that if we end up with a 4-4 vote, we may never know it. Because if they're going to be split and thus issue no precedent, my guess is they're going to dismiss this petition as having been improvidently granted. And here's the reason why. They granted certiorari to decide a case when it's admitted that the debt collector knew the claim was barred by the statute of limitations. But on oral argument, counsel for the debt collector waffled on that, and he wouldn't really admit that his client knew the claim was barred. So therefore, if they're not going to be issuing a precedential opinion, they could simply bounce it out on that basis, and then they've got a whole bunch of other identical cases in the pipeline. When there is a ninth member of the court, they can then grant certiorari again and then issue whatever decision they want to at the time. But let me ask you this, Professor. Is there any possibility that the justices might do more damage to debtors than simply ruling for the industry in this case?
Yeah, I would have thought that the stakes for consumers here were whether or not this practice of filing stale claims could be regulated inside of bankruptcy. But some of the questions, particularly from Justices Roberts and Alito, and even a little bit by Justice Breyer, seemed to express some skepticism that filing a stale claim, even outside of bankruptcy, would violate the Fair Debt Collection
Now, how have
Practices
the federal
Act.
courts come down on that issue of whether filing a lawsuit in either state or federal court on a stale claim violates the FDCPA?
So far we have 5 circuits that have all said that is a violation of the Fair Debt Collection Practices Act to file a lawsuit outside of bankruptcy on a debt for which they know that the statute of limitations has expired. So it would be really a monumental sort of thing for the court to all of a sudden expand this case from being isolated within bankruptcy to speak more broadly about the reach of the FDCPA. But there certainly seemed to be some hostility on the bench today about this notion that filing debts for which there's a valid affirmative defense could be an unfair debt collection practice.
Well, you know, I agree with you. I doubt the court is going to reach out and decide an issue that's not presented to them where there's no split of circuits. But on the other hand, they could drop a footnote or they could say something that casts doubt on the existing law in the circuits on non-bankruptcy cases, and you could end up with that case just 2 or 3 years from now. So I think that is very much a concern. Well, why is it that there is something about bankruptcy that might allow you to file a stale claim when you can't file a stale claim under current law outside of the bankruptcy court? What's different in bankruptcy?
Or the idea of bankruptcy is that you're not really filing a lawsuit, you're really resolving all claims against the debtor, and expired claims are still claims. You can't enforce them in court. You can't sue on the debts anymore, but they still exist. And for a debtor to have a truly fresh start, all prior debts would need to be discharged, including debts that were no longer legally enforceable.
Yeah.
And so the idea of giving a debtor a fresh start, bankruptcy code defines claims so broadly that it would include both expired claims and unmatured claims. Claims that are too old and claims that haven't quite come to fruition.
Right.
So maybe they should all come in.
Well, and also the fact is that a stale claim is still a valid claim. If a debtor wants to, the debtor can pay it. If a debtor gets sued but doesn't raise the affirmative defense of statute of limitations, the creditor wins. That's all there is to it. And so that, I think, is one of their more interesting arguments, is that Statute of limitations is an affirmative defense. Period. End of story. If you don't raise it, it's waived. And to that end, I think if the Supreme Court rules in favor of the consumers in this case, this industry is dead. On the other hand, Professor, if the industry wins and they can continue to file claims, stale claims, I'm not sure that they're eventually going to have a valid business at the end of the day. The reason is this. I think Congress doesn't necessarily have to change the law to stop this practice, because I believe it would be within the purview of the Rules Committee to change the 3,000 rules in bankruptcy that would make it virtually impossible to file a good faith claim when there is a known affirmative defense. So if the industry wins now, the rules can be changed and they may lose later on. So it could be this whole thing is just a flash in the pan. But tell me about preemption. Did that really come up in argument?
I was really wondering how the justices what they thought about the preemption argument. We didn't really get to it at all today in the oral argument. It was really just about the whether filing the stale claim itself is a violation of the FDCPA, and what would be the consequences to the court system if the court were to rule on the side of consumers.
Yeah.
So,
and you know, talking about the consequences of the court system, that was really the bug that Justice Breyer had in his bonnet. He said, maybe 4 times during argument, that the debtor's interpretation of the FDCPA means that disputes about the validity of claims are going to end up in district court, and he seemed to be worried about a flood of litigation, when the bankruptcy laws are all designed to bring all of those disputes into the bankruptcy court. Let me ask you this, though. Did the distinction come up much, Professor, between debt collectors and ordinary creditors in the context of the statute of limitations?
I was really waiting for this moment to come up during the oral argument where someone would make the point that we have a different treatment of creditors and debt collectors, which is really the crux of the Fair Debt Collection Practices Act. It really just regulates the conduct of debt collectors, not of creditors themselves. It didn't come up until the last 2 minutes.
And who brought it up?
The attorney for Midland Funding.
Really? You would have thought that the debtor's lawyer would have brought that up.
They, as if anticipating the argument that might come up, I guess, in chambers, Midland Funding brings up this point that says if you are worried about stale claims being filed in bankruptcy, then the Fair Debt Collection Practices Act isn't the place to look.
Why?
Because creditors could do this and not violate the Fair Debt Collection Practices Act because they're not debt collectors. So he made the point, if a bank were to file stale claims on its own behalf, they're outside the purview of the FDCPA. So banks could flood the system with stale claims. FDCPA only regulates the conduct of debt collectors. So if the banks had sold off those stale claims, now you're under the FDCPA. So he sort of, in a twist, in an argument I thought the consumers would have raised, the debt collectors raised and said, hey, if you're really worried about this, if this is really so bad, don't blame us, blame the bankruptcy code.
Well, and that segues us into, I think, the issue with which we will end this little discussion, and that is the court granted certiorari at the end of last week in another FDCPA suit, and how does that case differ from this one?
It's an interesting matter because in that case, right, the question is whether the purchaser of the stale debts was actually a debt collector for purposes of the FDCPA. Since the debt collector in that case had actually purchased the stale debts, they were no longer collecting the debts on behalf of someone else.
That's right.
So they might not be a debt collector. And you could imagine, as you were talking about perhaps dismissing the petition as improvidently granted, you could sort of imagine like this whole case might be settled very differently if we just said Midland Funding is not a debt collector at all.
Well, it's very possible that that new case could be argued before the end of the term, and possibly they will hold up both cases for decision at the same time. And if they conclude that if you buy a claim, you're not a debt collector, then that resolves the issue in this suit too. Cert improvidently granted.
Yes.
Isn't this fun? Don't you love this? Yes, I must say that watching the Supreme Court is great entertainment, and we recommend it to everybody. But meanwhile, we thank you for joining us, and stay tuned. We'll do this again when and if the Supreme Court argues the next FDCPA case before the end of the term.
Thank you.